majority.
Okay.
So if at least, you know, say their number is 12 and at least 12 of them, a quorum is a majority. So at least 12, and the number is 12, and say there's 11, well then they didn't have a quorum. So the guy doesn't stand trial. But say there's 13, well, it only takes 12. There's 13, so
Gotcha.
he's gonna stand trial.
Okay.
All right.
Thank you.
Any questions about any of this stuff? And on 28, it just kind of shows some of the testimony that you go through that may be in, you know, I guess a grand jury, what goes into a grand jury investigation. So when you get a chance, read through that stuff, and that's kind of what they have to, you know, kind of prove up or whatever. You know, just that the guy, you know, hey man, I had probable cause, you know, and maybe they're going to argue that he didn't have probable cause to pull the guy over, you know, because one of his headlights was out. Well, that is probable cause to pull somebody over. Pulled him over and had suspicion that, you know, maybe he was driving while intoxicated. Well, he had no reason to even pull me over. Well, he did. I mean, your headlight was out, so he pulled you over. So, the grand jury members consider all matters brought before them by the prosecuting attorney, who may be a state, city, or county attorney. The presiding judge administers the oath to the grand jury members in the courtroom and appoints one of their members as the foreperson during their deliberations. The grand jury is then instructed as to the law and their duties and responsibilities by the judge, which is the reverse order of that followed in the trial courts. The court reporter normally will report the charge, but is not usually transcribed. You understand what that means? Yes. No. Yes.
You report but not transcribe. Is that our job to transcribe?
No, your job is just to take it down. I don't transcribe everything that I take down. And all the county pays me to do is to take it down. That's all my salary consists of, is taking down what everybody says. So if somebody wants it transcribed, then that's extra. You know, but all the county pays me to do is to take it down. Any questions about that?
So then
No,
you
maybe
do
it's-
get paid, okay.
That's confusing.
So then the county pays you a salary, right?
Mhm.
So then here comes a lawyer, he says, I want a transcript. So then you're gonna charge him the $5 per page, whatever it is. That's something separate
Yeah.
to you? Less on top of whatever you're getting paid from the county?
Yeah.
Okay.
He said, were you not in your last class?
No, how does that?
He said, was it this year that you made
Yeah.
45,000 extra just in transcript?
And that doesn't include, and like I've told, you know, I don't make I don't say what I make publicly, you know. If somebody asks me, I'll tell them, you know, a court reporting student or whatever, well, I mean, what do you guys make? Or like if you sit in your court, what do you make or whatever? You can go online and see what I make. I mean, I'll tell you what I make. And I told the students last week, you know, our base salary down at the courthouse is $98,000. Yeah. And then, you know, like if you want, you know, a transcription of something, something to be transcribed, then they pay extra for it. And this was probably one of my better years last year. And this year's probably going to be about the same, if not more. And I probably made about 45,000 more this year. So all the county does is pay me to take it down. Now, if they want it transcribed, then that's extra. And that was the extra.
So then why don't you charge for rushes?
Well, I mean, if they don't want it overnight, then, or within 2 or 3 days.
That's what I'm saying, but I think, maybe I just misunderstood what you said earlier, if I do not.
I don't get to charge rush because the county pays for my transcription, because all of the attorneys that sit in my court are court appointed. So the county pays their salaries too. So they only get to charge so much for every hearing. They don't get to charge, you know, like if you go and hire an attorney, he's gonna tell you, You know what, it's a CPS case, I'm gonna need a $10,000 retainer. And that's not exaggerating. You know, 5 to 10,000 is probably about right. Just depending on how bad you wanna fight the department. You know, I've even heard of 20, 25,000, you know? So, but, you know, the attorneys that do work in our court are court appointed. So they're just on what's called a wheel. So there's so many attorneys and they say, you know what, we took your kids away, you can't afford an attorney, so we're gonna give you an attorney. So they just go on the next wheel and it's like, Mr. Barry Smith is the next attorney. That's who your attorney is. So you don't get to pick him.
But the retained attorney you can charge.
The retained attorney you can charge extra. But the county sets our rate because they're paying us. So that's why, you know, I don't necessarily get to charge for a rush. But, you know, sometimes I may tell an attorney, you know what, we took that hearing 8 months ago, and you go to trial, today's Monday, you go to trial on Wednesday, and just now you want it, and it's 600 pages, maybe not. Because I'm gonna work, you know, my butt off to get this thing out when this guy knew 6 months ago that, you know, maybe they needed it. But you're supposed to get it out. You're obligated to get it out, you know, most of the time. But I mean, when you know that attorneys are gonna need it, you know, and they're just sitting on it. Well, now they're trying to get a continuance because they need that thing. Well, you waited 2 days and, you know, to tell me, you know, hey man, we go to trial in 2 days. Knowing that, man, if you know, I can blame it on the court reporter that I need this transcript or whatever. And the judge, you know, and the judge has come to me. He's like, what's the deal? Judge, he came to me Monday. They go to trial Wednesday. Oh, no. He knew that he was gonna need that hearing. That was 6 months ago. You should have ordered it a long time ago. You know? But say you don't have anything else to do, and you know, it's only like 100 pages, and it's like, you know what, I can make $400, $350 for doing 100 pages. I don't have anything else to do in the evenings. Why not? You just made $350 for doing 100 pages. You know? So, you know, it's within reason, you know, but I mean, if a retained attorney comes up and he says, you know what, man, we do go to trial Wednesday, and it's 100 pages, and man, I need it. Well, I mean, we took this thing 6 months ago. Well, yeah, I know, but I need it. It doesn't matter, I need it. You know, what do you charge me? Maybe $8 a page. So now you just made $800 for doing 100 pages. But the guy wants a rush. You know, and you're gonna work. You're gonna work to get that 100 pages out. You know? But, you know, say he said, well, you know, we go to trial in a month and I need that thing for 100 pages. We don't get to charge $8 a page when you have a month to get that thing out, or even 2 weeks to get that thing out, 10 days. You know, usually if they want more than, you know, 7 or 10 days, then, you know, that to me is when it comes into consideration. And most of the reporters kind of feel that way too. You know, as long as they have about a week or 10 days, you know, but anything, you know, shorter than that, then you get to, you know, maybe charge a little bit more. And depending on what kind of hearing it is too, I mean, reporters charge for, you know, different kind of things too. I mean, whether it be, maybe they came in and it was just complete legal argument, or they just came in, or it was really simple Q&A. You know, if it's legal argument and they're citing a bunch of cases and you know you're gonna have to do a lot of documentation and look up stuff and whatever, you know, then you may charge a little bit more. If it's, you know, within that allotted, not within that allotted time. Does that make sense? So, you know, say he's like, well, we go to trial in 6 months, but I need that transcribed, you know, whatever. And it's about 50 pages of oral argument. You know, you just pretty much get to charge what the rate is. Does that make sense? Any questions?
So you take everything down, that you don't transcribe it,
No.
meaning like edit and put it all together unless somebody asks for a copy?
Yeah. Yeah. So really, you just store it. So really all the county pays me to do is take it down. And that's all I do, every day.
It's kind of awesome.
Huh?
It's kind of awesome.
Oh, yeah.
So you don't have to go through all that
Unless somebody calls.
You don't have to make like the official record or something. Oh, okay, I didn't know.
Yeah.
You go back on your everyday fix misstrokes or non-translates, or you just leave it unless somebody needs it?
You know, if I hear a word or something like that I may go through, you know, and especially like you guys, I mean, like my judge doesn't require real time, and he kind of thinks that it's something that's kind of distracting to him. You know, he's listening to the case and he's doing other things, like he's reading the CASA report, or he's reading the caseworker's report, or he's looking up past notes from past hearings or whatever, and it's like, you know, and trying to listen to the testimony at the same time. So he, you know, he's not there, you know, reading the whole thing or whatever. So, you know, sometimes I do it for myself, and I'll have my computer in there and I'm just messing around. And if on days that, you know, I hear something, I'll put it in my dictionary or stuff like that. But
It'd be more
yeah.
beneficial to somebody who's doing real time.
Absolutely.
So they could have it in the dictionary.
Absolutely.
Oh,
Yeah.
I never realized that. I thought every day you
That's the
transcribe
news.
No.
everything that you did.
Don't even
Oh,
transcribe
okay.
every single.
No.
Freelancers pretty much have to transcribe.
Oh, because that's why they're doing this.
Right.
Okay.
Yeah, I'd say freelancers probably transcribe about 90 to 95% of their stuff. You know, every now and then you'll go take a deposition, and it's like, well, we didn't learn anything more than what we knew already. So, no, we don't want it. Well, you still charge, and now the rate went up a little bit more because you didn't order the transcript. So now, you know, the rate will go up a little bit more because they didn't want it. But, you know, most of the time, you know, 95% of the time, maybe even higher than that, maybe 97%, that, you know, if they take the deposition, they're going to want a transcription of it. So as a freelance reporter, you're going to transcribe probably about 97% of your stuff.
Working official reporters have what are called backlogs. What are the backlogs being generated from? Cases that are being wanted from people, or just that they have to double check their work? Because I've heard that sometimes they get a backlog and they're forced to take their vacation pay to make up.
Well, and like me, you know, they changed some legislation about 2 years ago where, you know, it made it a lot easier when we terminated someone's rights to appeal it. Back then, you had to file all this paperwork. You had to set it for a motion for new trial. You come in, have the motion for new trial, the judge denies it. Then you have to transcribe the motion for new trial. The motion for new trial goes up to the fourth court. And if the fourth court determined that it was a frivolous suit, then they'll send a letter back to you, hey, you know what, it was frivolous. We need the whole record of whatever, and you know, send it back up. I mean, this was a process, just a process, and they're just like, so they changed legislation 2 years ago, and it's kind of like the death penalty on the civil side. Getting your rights terminated as a parent is like the death penalty on the civil side. So we don't really send anybody to jail. The worst thing we do is we terminate someone's rights. So it's like you never had that kid. That kid is not yours anymore, ever, ever. It was like that kid was never born to you. So that's, I mean, you're dealing with something very, very, you know, intense. You know, so they changed some legislation about 2 years ago that made it, you don't have to do that anymore. And much like a capital murder or something like that, if you get convicted and say you did it, I mean, and it goes to trial and you even say you did it, it still goes up. So it's an automatic record that goes up to the fourth court. Well, ours aren't automatic, but all you have to do now is fill out a piece of paper that says, I want to appeal it, and it goes up. So I used to go from having maybe 100 pages a month, 150 pages a month. At one point last year, or actually this year, I was probably right at 2,000 pages behind. 2,000. And in our cases, they deal with children. So, like on an appeal, we get 10 days. So from the day that they file that appeal, I have 10 days to get that record in. And they don't care whether it was 30 minutes or 5 or 6 days. on trial. You know, so it could be, you know, maybe you take 200, 250 pages in a day, and if it was 6 days, it's a lot of pages. And you have to crank it out in 10 days. So that's what they're talking about backlog. I mean, and I have a backlog of stuff, you know, so we get 18 vacation days and 12 sick days. So it's 30 days that you get. Out of 30 days last year, I used 6 days for vacation. I used 24 days to work on records. 24 days. So when you think, man, that guy made a lot of money last year, well, guess what? I worked a lot last year. You know, so, you know, it sounds good, and it is good. I mean, I'm not gonna lie, I mean, it's great, but, you know, they're not paying you just to sit there and look pretty.
But
I mean,
I'm
you're
just,
getting paid for what you do.
Did you take a lot of that work on the weekends? Or
Yeah,
did you
I worked,
really
guys,
hard?
I worked every day. Every day, probably the last year and a half. I've worked every day. And when I say every day, I mean away from my job. So I would work every day, at least an hour every day at my house. Friday, Saturday, Sundays, every day.
Yeah, but an hour doesn't seem too bad. I mean, I'm thinking
Well,
of it
I'm
in
saying on
terms of,
average.
you know, you have a family, you've got to juggle things.
Sure.
You know, kids in sports, so you've got to juggle all that within your schedule.
And they don't care that, they don't care about that.
Right, right, but I mean, an hour doesn't, it seems reasonable if you have to work on Saturday.
Well, I'm not saying an hour. I said on average, probably. I worked at least an hour. At least an hour. I mean, there's some days I would come here and stay here till 8:30, 8 or 8:30, go home, you know, eat, shower, or eat, sit down, work an hour, go shower, come back just to give myself a break, come back and work an hour, hour and a half. By the time I get to bed, it's 1 or 1:30, maybe 2. You get up and you do it all again the next day. So don't think it's all glamorous and, you know, the money's great. Don't get me wrong, the money's fantastic.
are taxes taken out already, or do you have to put them to the side?
On transcriptions, no. For transcriptions, no. So you have to pay your own taxes out of it.
Is that quarterly or at the end of the year?
You're supposed to do it quarterly. Yeah. And if not, then you calculate at the end of the year. Now, what I get paid, you know, by the county, that all gets taken out already, yeah. All right, any questions about grand jury stuff? Kind of got a little far-fetched. Okay, following the judge's charge, the jurors are taken to the grand jury room by the bailiff or the deputy marshal to hear the testimony regarding the case in which the indictments are sought by the presiding official. The court reporter is sworn as the official reporter and sworn to secrecy by the secretary of the grand jury. So you're really not supposed to talk about, you know, these things if you're the court reporter in a grand jury. You know, you just go and take it and go home. You know, people ask me about cases that we have all the time. Yeah. I don't really give like names, but yeah, I mean, I'll tell you, yeah, we had a case and, you know, they starved the kids almost to death, or this kid came in and was born, you know, with heroin in its system, and mom did heroin on the way to the hospital before she had the baby. You know, I just, you know, I'm not giving any names or whatever, but, you know, grand jury, you're not supposed to talk about it. The prosecuting attorney usually opens with a brief statement about the case and the witnesses to be presented, and the reporter will also report these proceedings, but usually does not transcribe it. So, I mean, unless, you know, they ask you to transcribe it, then, you know, you're not expected to transcribe it. The foreperson of the grand jury usually calls the witnesses by summoning the clerk from the outer room by a buzzer or a bell. The foreperson or clerk will swear the witness using the Bible as required in some states. Then the prosecuting officer will ask a number of questions regarding the matter under consideration, after which the grand jurors will question the witness. So they even get to ask questions, you know, regarding it. Readbacks may be requested when grand jurors do not understand testimony or when they wish to have a point reviewed to help them understand something better. So, I mean, they may say, well, you know, that's not what he said. Yeah, it is what he said. You know what, we're gonna need that read back. You know, what did he say about whether he thought the light was out or not, whether he had a tail light out or not, you know? Oh yeah, he did say that, that's right. The court reporter read it back. Yes, he did have the tail, oh, okay, yeah, okay. So, I mean, readbacks are sometimes necessary. When each witness is excused, a reporter may customarily leave the room with the witness so that discussion may occur secretly. In some places, however, the presiding officer will merely say off the record and allow the reporter to remain present. Sometimes a court reporter will be called back in during deliberations of the grand jury to read back testimony. So you're a unbiased party. So even if you are sitting in the courtroom, say you come and sit in my courtroom and the guy says, you know what, man, I did it. I did it. And you heard it. It wasn't on the record. That's not your job. It's not your job to go back and tell the judge, hey man, he did it. I mean, the guy confessed to it outside. He did it. You know, that's not your job. Your job is just to be an unbiased party, you know, and then whether it was a discussion between he and his attorney, you know, that's not up to you. You know, your job is just to take down when it's on the record. Okay?
So even though you have this special bond and relationship with your judge, you wouldn't tell him that when you're not legally supposed to?
You're not supposed to. You're not supposed to. You know, you're supposed to be an unbiased party. You know, and the judge is supposed to sit there as an unbiased party too and listen to the evidence. He's the evidence, he's the judge of the law. You know, and the jury is the judge of the facts. So they get to hear the facts and, you know. Arraignments and sentencing. An arraignment is a legal proceeding in which the person accused of a crime is brought before the court to enter a plea. The accused may plead guilty, not guilty, or nolo contendere, which means no contest. In a plea of nolo contendere, the defendant neither admits nor denies the charges, but throws himself or herself on the mercy of the court. If any defendant does not enter a plea at the arraignment, the court will enter a plea of not guilty. So, I mean, you get to come in and, you know, the judge usually will read the charge and then say, you know, how does the defendant plead? Not guilty. Okay. Or nolo contendere. Okay. So, when the defendant enters a plea and is adjudged guilty by the court, sentencing may be pronounced immediately